Thank you to the Camarillo Healthcare District for doing this series. I think it's so important to be able to get answers. I mean, if I could figure out a way to get paid for it, I would just talk all day about all the options and things we should know about. So thank you for giving this opportunity to kind of evangelize about some of these important issues. Sometimes I get to the end of the presentation and people say, now, who are you again? So I have a couple of things just about me so you know a little bit about me. There is a way that the bar can certify an attorney as a specialist in a particular area of law. There's about 15 areas of law that people can become specialists in, and one of them is this one, which is estate planning, trust, and probate law. So I am a certified specialist in this area. And then for some reason, my peers decided that I should be what they call a super lawyer. My wife laughs every time I say this, but I'm a super lawyer, honey. It is a real thing, and it's basically recognition. Top 5% of attorneys get this designation, so there you have it. But most important is just a little bit about me personally. If you remember nothing else about me, I was 4, violin, but I found out people prefer to listen to folk and fiddle and things like that. So if you've ever heard the Civil War soundtrack by J. Unger, the Ken Burns Civil War series, that beautiful soundtrack, that's the kind of music I like to play. So a little bit of that, and I am born and raised in the Rose City, Portland, Oregon. But this beautiful lady is from this area. That's my wife, Sarah. Remember that name. And so that is the reason I'm here in our 5 kids. The little girl in the front turns 9 today. So that is Mari. So, but remember, Sarah, there's a pop quiz at the end, and I'll explain why. But moving to why we're here, I look at this image and just think about it a little bit. And I just want to ask, this is a shot in the dark. It's a tough question, but what is that? Anybody know? That's a light switch. That's right. On or off? Well, we have one that's on, we have one that's off, right? This is what most people think when they think about capacity. Legal capacity, medical capacity, whatever the case is. They think you're either on or you're off. On to our eternal reward, and on means we're doing just fine. But the fact is, if we think about it a little bit, we're a little bit more like this. What's this?
A dimmer.
A dimmer, right? Something that, gets a little more, our brightness kind of declines as we turn it, right? So that is, in reality, what most people face as we age, which is that we're not just a light switch. We're not just we are a bit of a dimmer, and the how dim we get is a function of how well the rest of our medical needs are. But and frankly, things are very confusing, and sometimes it looks like this, and we've got switches and we got up and down and all sorts of things. But the reality is, it's a little more complicated than that switch. Frankly, if you ask me, I would much rather it be this, which is, when the time runs out, you're done, right? We got a certain amount of preset time. If we turn past 10, then we know exactly how much time we have left. But unfortunately, we don't, which is why attorneys do what we do, and especially why we help create documents, legal documents, that help transfer to other people when the time comes that our dimmer starts declining, right? So that dimmer starts turning, and we're like, okay, well, I can't manage this anymore. That may be more or less dramatic. That may be faster or slower, depending on who is, experiencing it. But these are the documents that are, I think, the most important. And, one thing about me, they don't have an elder law designation with the board, but really that's where my heart is. It's a subset of estate planning. It's caring about what happens to you. Yes, I care about who gets your stuff when you die. Of course, we all care about that. But I care about you and making sure you have what you need in place while you're alive. So, most important document, healthcare directive, financial powers of attorney, trusts if they make sense, and then wills are another document that transfers control, but wills only transfer control at your death. I see someone taking I will happily send these slides to you by email if you want. So my card is in your bags that you received today, and if you email me, I will send that to you. So you don't have to take the pictures, or you can if you like. No problem. So these are, in my some of the 4 most important documents that you can create to help with that dimmer situation. All right? So I'm just going to take them one at a time, and then we'll talk about some variations on the themes as well, and then we can touch on other things in your questions if we have time. First one is an advanced healthcare directive. Notice there's no D at the end of advanced. That's one of the most common, you'll see attorneys do this. They put a D at the end, advanced. Wow, it's very legally technical, so it must be advanced. No, it's advanced instructions to someone ahead of time, in advance. So that's what an advanced healthcare directive is. In the old days, these used to be called medical powers of attorney, and then they used to have another document. How many people have heard of a living will? All right, very, very confusing, because financial powers of attorney and medical powers of attorney would get confused. Living wills and dead wills would get confused, so they were just poorly named. So in California, those into a single document, and that's the advanced directive, or advanced healthcare directive. The main players in that situation are a principal and an agent, okay? So this is straight up agency law. This is we as designating someone else to receive the power that we're sharing with them over ourselves when the time comes. It's a great way to make your wishes known. You get to, the most important thing, you get to name an agent and backups. Remember I said we grow trees in Oregon. They're renewable resources. I will spend a whole ream of paper naming backups for you if you would like, because that's the most important thing you can do, is have people in place when the time comes. If that person goes before you, have backups. Make sure if you have that you have backups in there. You just don't know what the future holds. End of life care, of course, is very important, and that's the living will portion of it that is incorporated into this. You can touch on organ donation. There's other things we'll talk about, but these are some of the major things that get covered in a good advanced directive. Now, what happens if you don't have an advanced directive? Well, those are your 2 kids in the waiting room trying to tell the doctors and the staff what to do. And doctors, and they're going to listen to the squeakiest hinge, and that may not be the hinge that you want giving directions. So even if you even if you have good kids, it's very important to designate the one person at a time that you want to be making decisions. Is the post form interchangeable? It is not, and I'll touch on that in a slide or two. That's a great question. So our nearest adult relative is who makes decisions for us. If we're married, that's going to be our spouse, but by definition, one of you is not going to be there for the other. So, we need to look to other relatives to have people in place and to plan as carefully as possible whenever we can. So not all advanced healthcare directives are the same, okay? But it is my opinion that any advanced directive, because if you name an agent, you've done way more than most people out there as far as designating this is the person that I want to be making my decisions. There is a statutory form, and you'll see that adapted by various hospital associations and whatnot. And that form, as I've said here, it leaves much to be desired in my opinion, because I just know what you can do with these. But there's often, you'll know you're dealing with a statutory form if you have 2 paragraphs of life and you have to initial next to one of them. I'll bet a lot of people have experience filling one of those out. And let me summarize those. One says spare no expense, and the other says pull the plug. And most of us are somewhere. We're not on one end or the other. How about let's give it a try first and see how it goes? That option isn't in the statutory form. So again, it's better than nothing, but the pre-printed forms are not perfect. I recommend talking with an attorney and having something that's customized to your wishes. But as I said, naming an agent is the most important reason to have an advanced directive. Now, there have been some recent developments regarding making and proxy by proxy. One of them is just this year. Health care includes, under the statutes in California, includes mental health care, which is, I think, an important and good change. That was not clear under the old laws. So that make decisions having to do with the mental health of the person that you've been designated to help as well. And here is the post. I don't have a ton of time, so I didn't spend a lot on it, but if you're aware of what a post is, it stands for Physician's Orders Sustaining Treatment, POLST. It is not a good replacement. I'm not saying don't have one. I'm saying be aware that it is entirely voluntary, and it is originally intent was for end-of-life situations, people who are terminally ill, and they don't want aggressive resuscitation and whatnot that often happens when somebody is, loses consciousness or whatnot. So a pulse can be a very good thing in those situations, but it is not a replacement for your advance directive. You can't name an agent. And it is, in some states, not California, it is not even signed by you. So, there's some concerns that I have with the post, but again, the main thing to remember is you don't have to have one, and if you have an advance directive, you can be much more detailed about what you want and who you want making those decisions. And the challenge is, if you do have a post, even if it's an older post and you have a brand new, hot pink form is going to get the attention of the paramedics and whatnot, and they're going to want to do what's on that form. So make sure if you have one that at the bare minimum that it reflects your current wishes, and feel free to change it if you need to. Again, we have a limited amount of time, so I'm going to speed through some of these concepts, but we can come back to questions at the end. I'm just curious what this looks like to anybody. A penknife? Swiss Army knife? Okay. That is a statutory form power of attorney. I may not look it like it, but that is a one-page power of attorney that comes into my office very often. And this is the power of attorney you'll get if you go to an elder law attorney. You never need the wine opener or the toothpick, but if you do, boy, you're glad you have it. All right, so the idea with powers of attorney, and now we're talking about financial powers of attorney, the idea is to have a well thought out and comprehensive. I'll show you a picture of the statutory in a minute. You've probably seen it before. But the key thing is to, yes, basic things are important, but let's talk about the things that are not included in statutory powers of attorney and see if those things might be. So, like the advance directive, powers of attorney have a principal and an agent. All right, principal is you, and the person you're giving authority to make decisions for you is an agent. Like I said, there's a statute similar to the healthcare directive. It's made by the legislature. It's freely available. Most law library websites have a copy that you can download. It is better than nothing. So I'm never going to get on someone's case for having that. However, general in its language and it may not do exactly what you want. And generally speaking, all powers of attorney have pros and cons, which we'll touch on in a minute here. All right, so I mentioned that the uniform power of attorney for California is what it looks like. How many of you have seen something like this? All right, so it says I designate so-and-so to be my attorney in fact, which is a kind of an older term for agent. And then you get to initial next to a different powers that you want to have that person to have. If you feel very good about the person, you might just want to initial N, which says all of the above. And I would say that 99 out of 100 of these that I see have N initialed. But keep in mind, again, that they are not exactly, one size fits all, and that may not be what you need. So let's talk about powers of attorney. Here's some of the terms that you'll hear with regard to powers of attorney. Durable versus non. A durable power of attorney is something that continues on after you've lost legal capacity to make decisions. A non-durable power of attorney stops working when you've lost the ability to oversee it. And there may be situations appropriate, but most financial powers of attorney are durable. I would check yours if you have it and double check to make sure it says that it's a durable power of attorney. The other terms that you'll see from time to time are springing immediately. Okay, springing is a highly technical legal term, which means it springs into action upon some triggering event. Okay, I'm kidding, but that's what we do. We just say it's springing. It means, so oftentimes it's upon my incapacity. Upon my incapacity, something will, the power, my agent can start acting. What's best in these situations, having a durable or a non-durable power of attorney, having a springing or an immediately effective power of attorney, decision. The standardized form, the statutory form, is immediately effective. So you sign it, it's good to go. And there's some wisdom to that. Like I say here, if you trust somebody to do things right for you when you are incapacitated, keep an eye on them, then you ought to trust them to be able to have that power when you do have the ability to fire them. So, and that we touch on that in the advantages and disadvantages slides, which are coming up right now. So let's talk about some advantages of having a financial attorney. First of all, it's private and flexible. So unlike going to court, we'll touch for a second on conservatorships, if you've heard that term. The alternative to having one of these, and if you don't have one and you is going to court and having somebody appointed your conservator. That is not private, and it's not very flexible either. There's certain statutes that your conservator will have to follow. It can become very cumbersome also financially versus an attorney, which is probably one of the cheapest documents that an attorney can create for you, or if you use the statutory one, it's free. So they're economical. They can be put into effect right away. We don't have to wait for a court to do anything. Like I said, you sign that statutory form, it's in. It can eliminate, as I mentioned, the need for a conservatorship. Okay, it doesn't always, and I'll touch on that, but if, in most cases, it eliminates the need for a conservatorship. And it eliminates of your affairs on a trial basis. Remember I said you can fire somebody if they're not doing it right? Well, you can revoke a power of attorney. That's how you do it. You just let them know, you know what, you're done, I don't like what you're doing, and you appoint someone else. Straightforward. Another benefit is it doesn't require a formal transfer on title. So you can, a power of attorney agent can sign for you on a deed to a home, or they don't actually have to be on title. In fact, they shouldn't be on title. We don't want to add them as an owner. They're just the manager. Think of it as your store, but you've hired somebody to manage it. They don't own the store, but they're there. They can sign, they can do things and manage it for you. That's what a power of attorney is. So, and in certain circumstances, it can actually be used to create and fund living trusts, which, again, in certain circumstances can be very helpful. I will note that the statutory does not have that authority. You can't make gifts, you can't create estate plans, you can't do some of the higher end estate plan or tools that you would want to potentially be able to do with the power of attorney using that statutory free form. So these are consider talking with an attorney and maybe having a customized one drawn up. There are also disadvantages to having a durable power of attorney. First of all, a third party has to be willing to accept it. So if you walk into a bank's agent under the power of attorney, here it is, that bank can scrutinize that, then they don't have to accept it. There are certain circumstances where you can push that issue legally, but they really, they're concerned about fraud, and there's a lot of fraud with regard to these documents out there. So and I'll talk. That's where trusts come in. That's a way to maybe guarantee or make a better chance that you can have your agent or your fiduciary be accepted. But with powers of attorney, you have to have somebody willing to accept that power of attorney. It may not be fully understood by everybody involved, all right? So the people making it, and also the agent may not understand their duties. And they may be unable to gift to themselves, and you may say, well, why would I want that anyway? If your agent is one of your children and you traditionally gave them a gift, maybe for the holidays or for their birthday or whatnot, they can't. The law is very strict. If it's the basic appointment, that statutory form, they cannot gift, and they especially cannot gift to themselves. So there may be times when you want that to be able to happen, and so you have to specifically give that accountings. What did you do with my money? That's not automatic with the power of attorney. You actually have to ask for it, and sometimes you have to go to court and get a court order to ask for it. These can be very difficult situations if you appoint the wrong person and they shouldn't, getting the money back or getting an accounting for what was done. And along those same lines, there's no court supervision with a financial power of attorney unless somebody files a lawsuit, which kind of defeats the whole point. These aren't reasons to not do it. These are reasons to really pick the people that you trust implicitly and that you would stake your life on, and to stay on top of it, to remove those people if they don't earn your trust, and to make sure you're working with, if possible, an attorney who can help you if these situations arise. A related disadvantage, and this is where we touch on conservatorships a little bit, is that the retains authority to act. So here I'm going to get a little technical on you, but a lot of people say, what's the difference between a conservatorship and a power of attorney? The biggest difference is that a power of attorney is a sharing of my authority. If I've made my wife my agent, that doesn't mean I've lost the authority to act on my own. I can go to the bank and do things. It's just that she has the authority to do it with, in addition. With conservatorship, the court removes the authority from me and vests it in her. So I am no longer able to do my own banking or whatever the case may be. Conservatorship is a drastic step, and the courts are very careful about who they appoint and whether there's an actual need. Attorney, they're going to go through the paces and say, this should be enough. Why isn't it enough? And make you explain why. And here's the scenario, and I've had this happen. A person with a power of attorney, they've named a child or someone they trust, but as it progresses, as their capacity declines, they become fearful. They become paranoid. Not necessarily just regarding that child, but just in general. So they will go to the bank and take money out, hundreds of thousands, park it somewhere else in another account, and promptly forget about it. Well, the daughter, in this case that I'm thinking about, where I helped, came to me and said, how do I keep Dad from doing this? And the answer is conservatorship. Power of attorney. Power of attorney is a sharing, but the dad never lost the ability to go do it himself. Conservatorship takes that authority away. The banks are now informed there's a new sheriff in town, and so they only work with the conservator. So this is a disadvantage of attorney in that it doesn't stop somebody who has compromised capacity, which may be one of us at some point, from doing self-defeating things. So then in those cases, we sometimes need to think about. I mentioned a few minutes ago about trust being a good alternative, and so I just want to ask, since there's a theme here with a photo, does anybody know what this is? And no, it's not what you think it is. This is a trust. Trust. This is a dangerous thing. If you have a trust, the point of this picture is to encourage you not to leave your shoes and clothes in the closet, but to put it all in the very nice piece of luggage trust that you have, and make sure everything property is in that trust. Because one of the most tragic things that happens is people make a lovely trust. They go online, they download some document, they think they've got it all set up, they go to a notary and they sign it, and then they forget about it. And then they pass away, and we find out that property is actually in the trust. So, what do? We start from scratch, and the trust has no benefit. So, but properly done, trusts can provide many benefits. They allow for the management of your assets during or at death. So a big difference between wills and trusts is that wills, like I mentioned, only come into effect at your death, and trusts come into effect immediately when you sign them. And so when you lose capacity, those people that you've asked to, here we don't call it an agent, we call it a trustee, the person that's taking over and managing your finances for you under the trust, can step in as soon as needed. All right? And you get to, in your conversations with, to set what that criteria is. What's that triggering event? It doesn't necessarily have to be, as it is in so many estate plans, 2 doctors signing in blood and under oath that you're incapacitated. That's very difficult to get sometimes. This day and age with managed care, to get that second doctor. You can do something else. You can say 1 doctor who says under oath, or my trustee and a doctor combined, they have to say I'm incapacitated. Whatever makes the most sense for your situation, be that triggering event for when the trustee takes over. One of the biggest benefits of a trust is you can avoid the delay and cost of a probate. And if we have time, and it looks like we will, I'll talk about the costs are with probate, okay? So avoiding the cost and delay at your death of going through a court process is a big benefit to the trust. But again, managing your assets while you're alive. Privacy and control. Remember, privacy, not going to court. This is a private thing within your family. Nobody has to know about it unless people start fighting about it, which then it goes to court and everybody knows. And then in some cases, this is less important these days because the limits are so very high. We're approaching $13 million per person. That before you have that 40% estate tax, but that number is going to come down. We know that's going to come down by at least half in 20. You still have to be concerned about estate tax issues, so a good trust will plan for and around those situations. What is a trust? We've been talking about it. It's a legal arrangement by which a trustee holds legal title to property. Trusts have been around since the Crusades. All right, this is something that came from English common law and from medieval times. Somebody would go off to war or to battle and they'd say, hold my property, and when I get back, I want it back from you. Make it back, I want it to go to these people. All right, that's the original trust. And from that, we have the living trust that you've seen and might be in a binder on your shelf back at home. All right, but that's the idea of a trust. Similar to the powers of attorney, settlor, that's the principal, and it may be a couple. They create the trust. A trustee is who manages the trust, and the beneficiary is who gets the benefit of what's in the trust. When you create a trust, most likely those things. You are the settlor, the trustee, and the beneficiary. Sometimes, if you look at your own living trust, if you have one, it'll say grantor. Some of them say creator. I think that's a little presumptuous, but that's what some of them say. So a settlor or a trustor, these are the people, this is the title given to the person making the trust. But you're going to be all three when you start. You're going to be the trustee, you're going to manage your own assets, and you're going to be the beneficiary of your own assets. The question is, at certain points, will stop being those last two, and who steps in at that point? Who manages and who becomes the beneficiary. So authority transfers in a trust, like those other documents, at incapacity, at death. And it really is according to the terms of the trust. So you get to be as creative as you want in your trust and to set guidelines for when the authority transfers. You can have different successor trustees for different situations. Have trusts where the settlor says, well, when I become incapacitated, I want this person managing things for me while I'm alive, but at my death, I want it to be this other person. There may be reasons to do that. They may have a provision for a disabled family member, and they want to give that little piece of it to another person to manage. So you can be, as creative as you want with your trust. The trustees may continue to act after a settlor dies. I said, a new trustee may take over. So there's a lot of benefit to having a trust. And I mentioned that the powers of attorney are not always welcomed or accepted by third parties. But if there's a bank that has an trust, first of all, they ask you who's the successor trustee when you open that account. And why do they do that? They want to know who to expect when that time comes. And they want to be able to check it. Okay, is this the person we're supposed to see? But they already have a relationship with your trust, account in the name of your trust. So it is much simpler to get them to accept your successor trustee when that time comes than it is with the financial power of attorney. So keep that in mind when you're deciding, okay, should I have power of attorney or should I also have a trust? The problem, though, is that trusts only control the assets that the trust owns. So you remember that original image of the empty suitcase. If assets are not in the trust, you can't have any control over them. And so that asset would be managed by the agent under the power of attorney. Let me give you a few scenarios. Imagine that you win the lottery, right? And you're so shocked that you have a the 7-Eleven, and you never get a chance. Well, you're okay, you're going to be fine, but somebody else has to step in and manage things for you. So your your agent under your power of attorney can, using that power of attorney, lottery winnings into your trust. So that's one way all these documents work together. All right, what if you don't make it? That coronary was a big one. Well, then we do have what's called a pour-over will. It's an additional document for that one thing, the court would get that asset into your trust. But we hope everything's the best and you're going to recover and you're going to be fine, in which case your agent under your power of attorney can get the asset into your trust. Assets that we don't put in trusts. If you have a retirement account, a 401k, a 403b, an IRA, those assets are taxable. They have not been taxed yet. So when you pull money, you're going to pay, if you have experience with it, when you pull money out of your IRA or your 401k, you pay tax on it, dollar for dollar. And that's the deal we make with the ability to save money pre-tax when we're working. But if you put that account in your trust, unconventional wisdom says, well, that's a taxable event, so we'll tax the whole account. So we don't want that to happen, so we don't put your retirement accounts in trust. It's a reason why you have to have all these documents. Just one is never going to be enough. There's too many moving parts in our financial lives. So if you have a retirement account, that will stay outside the trust. We'll talk about who the beneficiary should be, and that's a very important question, and that's part of any discussion with an estate planning attorney. Actually transfer the account to the trust. We let that be managed by the financial power of attorney. All right? Generally, I touched on this earlier. I said if it's in there, you have the ability to amend or create an estate if it's in the power of attorney. But if it's not in the power of attorney, and if it's not in your trust, it has to be in both places, then you have your agent under your power of attorney does not have the ability to come in and amend your trust. You may be want my agent to amend my trust, but there are good reasons. Imagine, if you will, a scenario where after you've become incapacitated, it turns out that one of your children or grandchildren, somebody who stands to inherit from you, that they have a dependency issue. Or they're in an accident and they become disabled. Something like that, where getting cash at your death will be harmful to them. Right? We don't want to hurt people by giving them our legacy. We want them. So, if someone has the ability to come in and to make an amendment to your trust, even if you're incapacitated, if your dimmer is almost all the way down, it's okay. They can do that, and they can put provisions in, for instance, and they can protect the beneficiary so that they don't have cash fall into their lap and actually hurt them. They get the benefit without the cash. So these are examples of why we might want to have our trust be able to be amended across capacity. And I have been involved in those situations. In this, oftentimes it's one spouse who comes in and amends the entire trust for both spouses because the other spouse has dementia and is unable to do that. So these are situations are more common than you might think. And so we want to, again, have that discussion. It may not be right for you, but at least having that discussion with an attorney is important so we know what our options are. I mentioned this already. Of course, must be in both the trust and the power of attorney to do this. The law is very careful about giving this. I mean, this is a superpower if you think about it, to be able to amend somebody's trust, but it can also be very helpful. So we touched a little bit on conservatorship. Conservatorship is when your power of attorney or your advance directive are missing or they're just not enough. and we talked about why sometimes it might not be enough. If you are acting outside of your best interests, you're self-defeating, losing the money, or giving up, succumbing to a scam. There are scams everywhere. I'm sure everybody in this room has had somebody try to scam them. Hopefully none of you have fallen victim, but it happens. Has no judgment, because these are very sophisticated criminal activities that are out there. But if you go up to an ATM or a lot of times you'll see now signs saying, don't fall, or a Western Union kiosk or something like that, don't fall victim to scams, because they're all over. So again, if somebody's falling victim to scam, maybe we need to use a conservatorship to help protect them so they don't lose everything they need for their convalescence. So let's just talk briefly about conservatorship so you're aware of what the terminology is, and hopefully you never need it. But the main area that we think about for elder law is called probate conservatorship. That's conservatorship that probate court. There's also something called limited conservatorship, and then LPS conservatorship, which I do very little of, but I know enough about it to be dangerous. LPS stands for the Lanterman-Petrus-Smith Act. The act in California that closed the state hospitals, and we talked about treating people with severe mental illness in the community, and then what happens if they truly do need to be helped involuntarily. Well, then we have LPS conservatorship, and that's a function of allowing a conservator in that situation can allow for a 5150 or a 5250 and just allow for treatment, perhaps of the individual. But the main conservatorships that I deal with are probate and limited. A probate conservatorship is for an elderly person who has, or an older person who has a condition that's not going to get better. So oftentimes that's dementia, but it's something where they're going to need help, and it's going to be progressive, and they're going to need more and more help over time. So there are two main types: conservatorship of the person and conservatorship of the estate. These are almost self-explanatory. Conservatorship of the person you can think of as everything that you'd be able to do with an advance directive. All right, making medical decisions, deciding what treatments and medications and whatnot. Conservatorship of the estate is more in line of doing what you would be able to do with the financial, managing the money, protecting it, making sure it's there when needed. All right. Limited conservatorship, just so you know, and you can contrast it in case you're ever on jeopardy, and this is the final answer. It's for developmentally disabled adults. Somebody that has a child who's developmentally disabled, maybe they're a regional center client, and they are a little concerned about what happens when that child turns 18, and they still want to be able to help the child. This is where limited conservatorship comes in. So we do and I had some parents call me, and their child's 16, and they're already starting to think about it. And I said, well, we can maybe talk next year. Don't worry, it doesn't take that long. So, but that's, we want to be prepared, and parents have that very much on their minds. And like PS is for gravely disabled people who are dangers to themselves or others, and it's most oftenly initiated by a county hospital that handles 5150s. Okay. Moving on, we talked, when you think back to that list, advance directive, power of attorney, trust, the last one on the list was a will, and that is, right here, a letter to a judge. A lot of people think probate with a will, and I just want to set that aside right now. That's a mistake. A will does not avoid probate. A will just says that a judge is going to be involved. All right, so it's a letter to a judge, and it is a court process to distribute an estate. It is a transfer of authority, but it's a transfer of authority that requires you to die first. So it's not a good alternative for these other documents. But it's still good to understand how it fits into all of it. It's a court process to distribute an estate. If you have more than $184,500, that is the current number, that goes up every 3 years, then you need to have the full court probate. By the way, and we'll touch on this, there's going to be more more sessions, and so we're going to go into a lot more detail in a later session coming up this fall about what happens when someone passes away and all the options there. But I just want to at least touch on it so you know, first of all, that reasons why we should not consider a will to be all we need to worry about, because again, it doesn't do what all these other documents does. It simply removes the guesswork. It names your executor, or as my children say, executor, and it names those, but the judge will have a final say. And most frustrating for people is that it's lengthy, costly, and public. These are just some examples of how much the attorney and executor fees are. If you've got $1 million, and you might say, I don't have $1 million. Well, guess what? It's the gross value of your house. Now add that to what you have in your bank, and you might actually be closer than you think. So that's a $23,000 attorney fee, $23,000. There's fees for filing every petition involved. So, I mean, it really gets closer to $50,000 by the time we're done with just $1 million estate. So these are reasons to, in and of themselves, to be thinking about doing something other than just a will. A lot of people have the will, power of attorney, healthcare directive, and they think, that's it, that's all I need, but maybe that's not the case. So I just want to ask, and I want to leave time for questions. We're wrapping a little early because I want to make sure plenty of time for questions. But how is your plan? Do you have one? And does it avoid conservatorship, which is a big thing that we want to avoid if we can? Are your healthcare related wishes clearly in an advance directive? And maybe you set them out at one time, 15, 20 years ago. Do they still reflect your wishes today? There's been a lot of advances in medicine and treatments. We don't necessarily approach it the same way as we did set up your estate plan. Is your power of attorney durable? Does it give authority to the people you want? And remember, you can name plenty of backups so that you don't ever run out. You never want somebody guessing. And in my practice, I've never had a person come to me and say, I'd wished I'd taken longer to do this. They actually say the opposite. I wish I had done this years ago. So, Murphy's Law of estate planning is that if you do it, then you're going to live another 50 years. So you might as well just confront these issues. But with that, I just want to open it up to questions. We can go into more detail on things if you have time, but I do see some hands, so go ahead. And so the question was, does a 5-year-old estate plan automatically update? Does it need to be reviewed with an attorney? And the answer is it's multifaceted, because I wouldn't want to tell you not to talk to your attorney because I don't know what's in your document. Frankly, trust and those documents will control to what extent they automatically update versus need to be manually updated. So that's actually in your documents as far as what needs to be done. But here's what I tell clients. Every 5 years is a great time to just sit down, pop the hood, and say, is this still working for me? Is it exactly what we want? Have there been changes to the law? Have there been changes to my family that might necessitate a review? Almost every attorney will do a complimentary estate planning review in that kind of interval. Frankly, people don't. They come to us, they blow 2 inches of dust off of it when somebody dies, and they say, well, I hope this still works. And the fact is, I would say avail yourself of that option if your attorney. If you are with one of the very few attorneys that wouldn't do that, then please feel free to come to our office. I'd be happy to take a look at it. But I would say go back to your attorney and say, hey, does this do everything that we talked about 5 years ago? There haven't been such dramatic changes outside of the estate tax world that I think that I would say absolutely you must make an appointment and run into the attorney. But it's always a good idea on about a 5-year interval to do that. So remember I said the pop quiz about my wife's name? I am terrible with remembering phone numbers, so now you'll never forget the number to reach me. It is 246 Sarah. That's my wife's name, no H. She's a very proud part of the No H Sarah Club. So anytime, day or night, and we will only answer during the day. But now you have that number. So that was the pop quiz there. So the question was to talk more about determining capacity and what the triggers might be. That's a great question. You know, when I was going through what slides to have today, because I knew we had just an hour, I took out some that had to do with that very question. So first of all, I want to say that under California, we are all, and this is Probate Code Section 810, we all have the capacity to do the things we set out to do. That's the basis, the first thing that the law says. But it throws an extra word in there that we have to be careful about. It says there is a rebuttable that we all have the capacity to do what we're set out to do. And that rebuttable is the issue. So that's really the heart of what you're asking. Because what is going to rebut that presumption that we have the capacity? If you don't have it in your documents, then a court will have to make that determination using medical evidence and whatnot. So that's why it's important to get it just right in your documents. So what are some examples? I gave a couple. I will say that 90% plus of estate plans say two doctors have to, who are unrelated to me, they say two physicians who are unrelated to me by blood or marriage must sign off on me. Oftentimes it says that I'm incapacitated. That is very, very difficult for a couple of reasons. I'll tell you. One is not all the people qualified to make that determination are physicians. Later in this series, I have a presentation by a doctor, a neuropsychologist here in town named Eric Landy, Dr. Eric Landy. He is well-known, well-regarded. I'm honored to be on the panel with him that day to talk about capacity issues in much greater detail and losing capacity and whatnot. Dr. Landy is not a physician under California law. He's a neuropsychologist, but he's an expert and well-regarded. Wouldn't you think he'd be one of the people that could potentially sign off on whether you're incapacitated or not? Yes. In estate plans that come to me that say two physicians, I can't even think of using Dr. Landy. That's very frustrating. So all of my documents say doctors, qualified doctors. You know, if you're a doctor of law like I am, then that's, but somebody that's a neuropsychologist certainly is qualified, a geriatric neuropsychologist. So that's, these are the things, the fine tuning when it comes to these determinations. The other is under oath. You might think, and I often do, well, if in writing, they ought to be willing to make it under oath, under penalty of perjury. But there are some hospital systems that actually don't want their doctors to do that. So that becomes an impediment. I won't name them, but it becomes an impediment to sometimes getting that. Even if you have a dermatologist who's treated you and knows you, if they are under their system's restriction from putting that penalty of perjury language in their determination, then that can become an issue. So thinking through these things, and in my mind, the way I was saying this, don't make it too difficult. You're asking somebody to help you. Make that hurdle as low as you can while still feeling comfortable. I have seen trusts come to me that say, well, if my spouse is living and he or she determines that I am incapacitated enough. And you might think, well, that's kind of a risk, but in which case I would have been determined incapacitated a long time ago. No, but the fact is that something like that can be perfect for situation. And all of a sudden, we've removed the barrier. You're asking someone to help you. And sometimes it's not spouse, sometimes it says if my successor trustee and my primary doctor together make a determination. That's actually the one I like the most because it involves medical evidence, but it also doesn't have two doctors or two physicians involved. It is just hard to get that second doctor sometimes. You have to go to a specialist and try to get them to do it. So does that answer your question or help? It would be carefully, but those are some options. I will say, this brings up something. I will say a lot of trusts that are out, the estate tax threshold is almost 13 million. It will come down, but still for many people, including myself, it's not going to become an issue when it's down in the 6 million range either, okay? So a lot of trusts that were done 15, 20, 25 years ago, the split is what made me think of this, that say that when my spouse dies or when the first of us dies, the trust has to divide. And you'll hear terms trust A and trust B, or a bypass trust and a survivor's trust. This is really, we're getting into some of the territory of the later talk, but we'll go into more detail in that talk. But those trusts are often completely unnecessary now. And so it's very easy to go in and modify the trust while we have the two settlors, avoid that unnecessary division of the property, which requires a separate tax return be filed and separate accounts and things like that. That was done because we wanted to preserve the estate tax exemption. You know, in 2000, the exemption was $675,000. It's gone much higher now, and you know, you could have paid 40% or 50%, depending on the situation, above that number. So people had very good reason to have these trusts back then, but they just don't apply to most people now. Around with those trusts, and the only way to fix them really is to go to court and ask a judge to modify that after the fact, which is a hassle. So if someone dies and you realize, oh, I have that trust, so better to do it while both spouses are possible and just get that taken care of. It doesn't need to be that complicated anymore. But that may be what they were talking about with the split trust. So the question is, for the television audience, is about a trust that was done in 32 years ago, and it was, and a lot of the people involved have passed away since then, and then you have actually handwritten on it, so there's some interlineation there. So all of those things, I'm going to use you as an example because you've mentioned all of that, just to say these are, first of all, I want to say that your trust never expires. So if it was valid at one time, it's still valid. To the extent it can get the job done, it will. So do not throw it away. Okay. So I highly recommend that you revisit it and perhaps restate it, or just make it meet your needs for today. So that can be done relatively simply by an attorney just talking to you today about, okay, away, what would you like to do now? And so revisiting that makes perfect sense. What doesn't make sense is leaving it to guesswork, because those interlineations, say that you wrote somebody out or you made a change to percentages, people may get upset and they may go to court over that down the road. You never know. So if they're not here to argue, maybe that's a blessing. I guess my point is this: I highly recommend. 5 years I mentioned as a good interval. Certainly, when we get into the third, people have passed away, I strongly recommend that you sit down with somebody and say, let's make sure this works, so that we're not going to cause the people I'm trying to leave my money to. You don't want. Who has read Bleak House by Charles Dickens? It's one of. But in that book, there's a couple of there's a will and there's a probate, and it's called Jardice v. Jardice. And the bottom line is the attorneys get the whole estate. There's nothing left when they're done fighting over it. That is what we want to see happen. I want to figure out other ways to get my kids through college than on your retirement and your legacy. So that's all. That's my thought. Yes. So the follow-up question was also excellent. It said, if I do the amendment, do I title on my assets, right, that you've already put in there? And the answer is no. Once you have a trust that's born, it has a name and a birth date, and that never changes. Even if you take all the guts out and put new stuffing in, and that's what I'm proposing. It does have costs because that takes time and effort on the part of an attorney, but it's much, much more potential costs if there's people fighting over it in court later on. So, but you don't have to retitle the house or the accounts. They'll keep the name and date just the same. So, to start from scratch. I also mentioned, if you're driving home today and you think, wow, I should have asked that question, feel free. Just I'm happy to have a conversation with you about any of the things we talked about today and go into greater detail. Maybe there were things you didn't want to share, and that's fine. Okay, we can go into it privately and confidentially. There is in your bag upcoming talks. That one on September 18th is the one I mentioned with Dr. Landy. That's going to be, they're all going to be excellent, but that's the one where he's going to be here talking about, does my parent have dementia? And he actually has a book called Does My Mom Have Dementia? So that's where we grabbed that title. October 16th is the one that I've mentioned a few times, where I'm going to come back and talk about things after someone's passed away and how to handle that. So it won't touch on the powers of attorney and advanced directives and things like that, but it will touch on to know about this area of law. So please consider signing up and coming to those presentations, and please make me your resource if you have any follow-up questions. I'm happy to help. I want to give a plug for the Monday afternoon. Monday afternoons at the healthcare district just up the road, there is you can sign up for a no-cost consultation with an attorney. It might be me, it might be one of our other 13 wonderful probate and trust attorneys. They're just colleagues of mine throughout the county who are very good at what they do, and then we all take turns so that we each come about once a quarter. And so you call the healthcare district and they will set a time for you to come in, and you could bring, for instance, you could bring your trust to look at. Yes, this looks great, or I might make this change or that change. So they won't actually go and do the changes. You're just there for an hour, but they will tell you answers to the questions you have and hopefully give you some peace of mind. That's a 1 to 4 p.m. every Monday afternoon at the Camarillo Healthcare District. That's been going on for 20 years, and I'm honored to help schedule those attorneys. And so please let your friends and family know that's an option as well. Okay?